Well, this might be one of our stumbling blocks in the Supreme Court. You got all these people in power saying, "Oh, what a great man he is." It's getting received the highest approval rating among the leaders from across the three branches of the federal government, according to a new poll in which Roberts was the only official to gain majority support from both Republicans and Democrats. Well, that doesn't make, it's not a feel-good sign, people, I can tell you that. Let's see. Now, he's all excited about this Roe versus Wade thing coming up. You know, they might lose power in the court. Well, here's the thing, people. This is let's see. Clear purpose of the act has been to nullify the court's ruling. Is, however, the basic principle of the Constitution is fundamental and paramount law to the nation. Okay. And it's up to the Judicial Department to say what the law is. Roberts wrote, citing the 1803 ruling in Marbury versus Madison, which established the court's role as the interpreter of the Constitution. No, see, you got Roberts already trying to interpret the Constitution. That's not what it says. It says it's the supreme law of the land. It doesn't mean that the Supreme Court is the interpreter of the Constitution. He sounds like Holmes back in the day. You know, oh, well, the Supreme Court interprets the law. No, it's not to be interpreted. Doesn't need to be interpreted. That's the problem with when you put these people into power. Thomas Jefferson. He was a very impressive thinker, and he put this into words so people would understand. On every question of construction, let us carry ourselves back to the time when the Constitution was adopted, recollect the spirit manifested in the debates, and instead of trying to what meaning can be squeezed out of the text or invented against it, conform to the probable one which was passed. I said before about how these people how laws have been changed. But 150 years ago, things started getting changed. They went from Blackstone's law to case law. Following the Civil War, some influential individuals embraced a new idea, Darwin evolution. The Origin of Species by Charles Darwin in 1859 had an impact on the movers and shakers who saw no room in American jurisprudence for Blackstone's God-based view of nature. So there was really a deliberate effort by the president of Harvard University, Charles Eliot, to change things, to introduce evolution into the teaching of law. So he hired Christopher Langdale as the dean of Harvard School from 1870 to 1895, who changed from using Blackstone commentaries that had all the principles to a case law approach, studying the writing of judges. But these judges started to get more power from the new political experiment. In my constitutional law class at Vanderbilt University, one of the better law schools in the country, we never read the Constitution. We only read what judges said about it. So they did away with the Constitution. The judges became laws unto themselves, people. That's what has happened. That's why you have political laws now and not constitutional laws. Give me a second here. Let me get my bearings straight. From food stamps to art subsidies, government today is everywhere. It wasn't always so. It may have only in the future. In both Congress and the Supreme Court, moves are about to return power to the states and to the people in areas ranging from welfare to environmental protection to crime control. That would please the founders who gave us the Constitution for limited government. Under our Constitution, our federal government has delegated, enumerated, and thus limited power. Power is delegated by the founding generation or through different amendments and make it legitimate, enumerated in the Constitution. That makes it legal, and they are limited by the enumeration. As the 10th Amendment says, if a power hasn't been delegated, the federal government doesn't have it. For 150 years, that design held for the most part. When faced with a welfare bill in 1794, James Madison, the principal author of the Constitution, rose in the House to say that he could find no constitutional authority for that bill. A century later, when Congress passed a similar measure, President Cleveland vetoed it as beyond the Congress authority. All that changed with the New Deal as both Congress and the President sought to expand federal power. When the Supreme Court objected rather than amend the Constitution, Roosevelt decided to try and pack the court with 6 additional members. The scheme failed, but the threat worked. Thereafter, the court started reading the Constitution's general welfare and Commerce Clause so broadly that the doctrine of enumerated powers was essentially destroyed. And with that went limited government. Through those 2 clauses, Congress has created a massive redistribution and regulatory state that surrounds us today. Now this thing about gun control, they have no power. They never had power or the authority to do it. The Second Amendment to the Federal Constitution recognizes that a God-given right to keep and bear arms is to be free from any interference whatsoever from the federal government. All of our rights come from God and are unalienable. Accordingly, the federal government is nowhere in the Constitution granted authority to abridge, restrict, or infringe in any fashion whatsoever guns or ammunition. Thus, all restrictive laws made by Congress, all regulations made by the Bureau of Alcohol, Tobacco, and Firearms are unconstitutional as outside the scope of powers granted to Congress and to the executive branch by our Constitution. Restrictions of arms and ammunition is not one of the enumerated powers delegated to the Congress or to the executive branch. Well, people, that pretty much sums things up. I hope you can understand that. I hope you understand that the Supreme Court really not quite on our side. They're making political laws and not constitutional laws, and expect you to follow it. And Judge Roberts saying that it established the court's role as the interpreter of the Constitution that is a bunch of shit. That's not what it said. It's the supreme law of the land. It has nothing about the Supreme Court having all that power. It's not to be interpreted politically. It's supposed to be a neutral area. And this guy here is treating it like, hey, this is my stomping ground. Well, it's not your stomping ground, bud. The Gallup poll in September found that the Supreme Court's job approval had sunk to 40%, the lowest level since the polling began in 2000. It's all because they're not following the Constitution. You understand that, Roberts? That ain't Roberts, is it? Maybe so, who knows? Now, I'm sorry, Roberts, you do not have my highest rating among the leaders out there, because you're still going by the old political way what you were taught in school. You still studied the writings of other judges. You didn't study the Constitution. You didn't study the Federalist Papers. You didn't study the Anti-Federalist Papers. I doubt very much you read the Declaration of Independence. That's where the law lies. You've got to go back. You've got to go back to when this started. Now, they set up an archive of the Federalist Papers years, many, many, many years ago, so that people could study the law about the debates and everything that went into the Constitution. And you're saying, well, history doesn't mean nothing to me. I'm going by what these judges said. But like I said, when you study the writings of other judges, you're making them the law and not the Constitution itself. Men are mortal, and mortal men make mistakes. You're going to make a big mistake if you don't follow the Constitution the way it was written, not the way you want to interpret it. And that goes for every justice that's on the Supreme Court right now. Follow the Constitution. We're tired of political laws. You've got to go by the Constitution. You give us constitutional laws, that's something you can follow. The other stuff is just hearsay, they're null and void, and means jack shit. Thanks for watching.